right, next witness. Cross-exam.
I have no question.
Yes, okay. Any other witnesses? Any other exhibits? Evidence.
Legal argument.
Any rebuttal? Argument?
All the documents in this case satisfy all statutory requirements, all necessary steps are taken to ensure that notice is sent to the interested parties of the record. Of course, those are all no requirement that notice is actually received for the reasons you took the case. The evidence in this case shows it was received. It was received by the owner of the property, which was Frontier Bank as trustee of trust number 1865. They were served as highest ranking officer in Indianapolis Boulevard, Thailand, was served on their resident agent for that trust. As the court is well aware, the determination of the court determined whether the notice was given in such a manner as to be confidential of the pending loss of his interest in the real estate. That was done. There's an obligation claims to notify beneficiaries of the trust, whether they receive notice or not, or whether notice is even attempted upon them is of no significance in this case. In fact, the person put the property in trust often for the anonymity of the beneficiaries who they were. The obligations of wintering, Your Honor, and the court's obligations are clear. In order to issue a tax deed, deed is to be given if the court finds that the notices have been provided to the statute, we believe they have been, and the law requires us to be in substantial compliance with the notice provisions, and we are. That is the request for the tax deviation for the three-part budget.
I guess I would begin by without rehashing my argument, bringing it to the court's attention again that we believe that there was not substantial compliance with Section 415 and 426 as far as the technical. There is no evidence of proving to be served by testimony or by way of evidence. So I would guess without belaboring the point, I will raise that one more time. In addition, I would direct the court
one again?
It's the, I think it's the first 009. All the
Yeah, the very exhibit 1.
31.
Oh, okay. Yeah. Okay.
If you look at the top where the owner of record says Frontier Bank ERS fails to include 1865 as required. There's been testimony that given that Frontier Bank would have more than one trust because this 1865 was not included on this pre-sale notice. It is a failed law in the pre-sale notice. The court is well aware that all three of the notices must be compliant. I would also point the court to Enray the matter of 2007 tax sale in Lake County, Indiana, Ralph Bullitt, I think, versus James O'Keefe, which talks about the fact that missing information that's contained in the auditor's records but not included on the notice is stated. I have a copy of that case for the court as well.
All right, so your position is, I assume these three, I can't tell necessarily what, did the three of them sell together for one price, or did they sell separately? It looks like they both sold separately. And I'm trying to, the argument with regard to the failure to put the trust number on the pre-sale notice of 009, are you saying that is an argument to invalidate that particular transaction but not the other two, or somehow
I don't see how the one can apply to the other. I agree, yes.
Okay.
So
you're saying
we're
that...
talking about 009, and that's what I think I kind of meant to put these together, but there will be some separated arguments.
Right,
So
I
right
understand.
now I'm separating off to just talk about 009.
Talking about 9, you're saying, here's one reason why 9
Right.
should be invalidated,
The
because it
previous
didn't.
argument was all encompassing.
Right.
Now we're focusing just on the 009.
And what did 009 sell for? Yeah, okay, I see that. That's exhibit 1, isn't it?
Tax sales certificate.
Okay.
But the argument that
Okay.
Sonic
Go ahead.
Wait.
No, no, I'm just taking this. Go ahead.
With regard to this particular pre-sale notice, failing to include a trust number when sending it to the customer, the state out of the trust department to be able to track down what property it was. And if you were to look at the evidence presented,
Well, just so you can address it now, because I'm sure they're going to bring it up, it's they could have done it by the anniversary.
that's not substantial compliance. I don't know how they correct this.
Well, I was just addressing the
Right, but I
statement.
don't
The
think-
statement you made was,
That-
how could they track it down? And
Right.
I just wanted, I'm
Without-
sure they're going to say they can track it down. But the honor said,
Without
so
a-
address that now rather than
I
later.
appreciate it. Without the trust number on there, I think that it is a material flaw, particularly if the court were to review the property, real property maintenance report that's included.
No, I think clearly that document shows.
The property maintenance shows that it should have been included on there, that is part of the name. The case that I was citing to indicated that when an agent's name was included in the records, but not used on the notices, that was a fatal flaw, and therefore the tax sale for that particular property should be set aside, as it does not fit the property. And it would not allow for the notice to be approved as testimony from the beneficiary. There was no information that got to them on this particular case. Due process requires that they get notice and requires that the name that these are included properly included pre-sale activity. And to be clear, I'm not suggesting that it's not about pre-sale notice. The court is aware that all three notices have to be compliant. Did you want a copy of the case?
Yes. Okay, and then the argument with regard to invalidating all 3. Is there any additional arguments other than the argument that
I
they
can
didn't
rehash
prove?
the argument that I made
Okay.
before, but I think the court's aware of my position on that. So I guess I raise it by relating back to the argument that I made earlier.
Specifically that there's no evidence submitted as to who the substantial title holders were.
Right, so that there's no, well, so there's no evidence as to who needs to be served as a substantial interest of public record. Substantial interest of public record includes lien holders and owners. Substantial compliance with 4.5 is required. And because we don't have the evidence to determine whether or not there was substantial compliance, then I don't think that the court has the information to say that there was material compliance.
Anything else? Rebuttal?
If there is compliance, yep, plus the number of the sale notice, plus the sale to be effective. The key number is there, the property address is there, track it that way. But worthy of notice, also in Exhibit 31 are the notices for the other 2 properties, which did have 1865 indicated on it, and they were all signed for by the same person at Center Bank. They got the notice, tie it together very easily, all the information is there, the same person had it in their hand. but we do not believe that, in fact, that's effective as to the pre-sale notice. The owner of record in this case, the Sincere Bank, did receive the notice and subsequent notices as well. There is no prejudice to them by not having the 1865 indicated on that one. All the other information is there and has included his substantial compliance. That's exactly
Pretty wild. I'm going to take it under advisement, but I'm going to ask that the parties file a proposed order, and I want you to address in the order all the legal issues that were raised in essentially memorandum format. With regard to the issues raised, with your legal citation, so I can read it. Obviously I'll read this case. If there's any other authority, I want each of you to stake out your positions in writing, in a form order, requesting the relief that you think is appropriate. How long will it take for you to 30?
30.
Parties will file their proposed judgments within 30 days. Again, I want the legal issues to be addressed in that with proper citation, memorandum format. And since we're going 30 days out, I'm going to ask you to wait trial. All right, very well. Is this for me or?
Sure.
Yeah, you can actually
Okay.
give to Paris. That's wonderful.
All right.
You should probably have it.
We have to make a
Thank you. Well, it's nice, handy to have it all in one place. All right. We have one more on the 9:30 call, and it's a dual case of First Bank of Whiting. Are we ready on that one? 524 LLC. Who represents them? Attorney Schuster
Yes.
and attorneys Megan and John Craig appear for First Bank of Whiting. Attorney Wiley and his representative Scheid is here. No, that's it. No, let me see that. That's 7:30. Are we ready to proceed?
Yes. Yes. My name is Roach.
All right, 1 through 27.
Yes, that's correct.
You have an opportunity to review 1 through 27.
Yes.
Any objection? Exhibits 1 through 27 as presented to provide their witness. Any witnesses?
Yes, call David Brock. State your name, please.
David Bronx, PR.
Relationship 524 LLC. And to be upon 4519.22.326.001.00038 and 45-19-22-377-002.000-038, which I'll refer to for brevity, or 326 and 377. You indicated you did the noticing, and I assume we're talking about the 4.5 and 4.6 noticing. With respect to 4.5 notices, I noticed in the exhibit I might have closed.
Yes, you may.
You prepared, set that notice? You went to 4 addresses. One of those, the address of record, Westchester, Illinois. And there's one sent to Center Bank or to First Bank of Whiting, which has at their corporate headquarters in Maryland, is that correct? There's one sent to P.O. Box in Whiting, and then one, I believe, to 119th Avenue in Whiting. Those last two we talked about, P.O. Box in Whiting and 119th Avenue in Whiting. Do you recall why you sent it to those 2 addresses? And at the time you did that, was it your understanding or belief that there was a mortgage on the properties that we're talking about? Did you later learn more information on that, on the existence of that mortgage? 4.6. Did you send your 4.5 notice by regular mail? And would that be exhibits 12 and 13 for the two parcels? And did any of those come back? The ones that you sent by regular mail, were they returned to you? You also sent a 4.6 notice by regular mail. Do all four addresses again? It would be exhibits 24, 25. Were any of those returned? Your regular mail ones, not talking.
Regular mail is
I know. I have a quick question.
Cross-examination. Which one are we on? 3.
Several.
Keep going.
The first page is exhibit 4 is the auditor's certificate. The second page is the property maintenance report. And the third page is
Yes.
and this particular property, the other, you're correct, this is 45 and address that's listed on the transfer card the same as the one that was listed on the street? In other words, does it say here on SSAY? And then we're going to go ahead and go on to Exhibit 5, which I believe is your 4.5 notice. And Exhibit 5, you list the 4 addresses in which you sent notices. Is that correct? And do any of those addresses include care of SSA1? Okay, but a question before you.
Objection,
To
something.
just the question is, do any of them include SSA1? Was SSAY Corporation served? Will you only serve persons with an ownership interest, not just an interest in the property? Do you serve people other than? But under your review, SSAY was not a substantial, did not have a substantial component. And the 4.6 notices were sent to the same place for the 4.5. And you published in the filter little tributes. Did you publish any of it? And then I'd like to direct you to Exhibit 27. Contains the pre-sale notices for both properties. Either of those included in the owner of record care of SSAY report. Objection, Judge, does not.
Just, the question simply doesn't include it in the documents.
All right.
Redirect.
Did First Bank writing trustee, trust 1865, receive 4.5 notice? 4.6 notice? Received the pre-sale notice? Those documents are all shown as exhibits. I have them.
Cross. Attorney Wiley, do you have any questions? You may step down. Attorney Schuster, any other witnesses?
No, I didn't.
Any other exhibits to proffer? To arrest? Which witness? morning again.
And what is your relationship to the owner of this man? First banquet wedding present? Are you familiar with the corporation SSA? What capacity are you familiar with? And since when have you been engaged with Did you receive? Right.
Cross-exam.
What state is SSAY Corporation incorporated? Is that the full name of the corporation? There's no certificate of doing business name on file showing SSAY Corp as the name for that corporation. What state's that in? SSAY and Sons Management Corporation doesn't own the property. First thing, why is such a reason? I have a quick question.
Redirect.
Just to clarify, SSAY manufacturing
Recross.
In what name is it registered? Is it SSAY?
Overruled.
Under the name of SSAY and Sons Management Corporation. But there's no assumed name certificate indicating that on record, is there?
Lee Wiley, do you have any questions? You may start. Any other witnesses?
Yeah.
Franchetti?
after he passed away, did you take any action to have the mail forwarded from 165 West Chester?
Yes, I did. I registered at post office box and
And in order to forward the mail, they fill out the card.
yes.
What name or names did you put on the card?
John David, SSC1.
And at that P.O. box, did you receive forwarded mail that had previously been addressed to 135 West Chester?
Cross-exam.
Did you get the notice of tax sale that was sent to that address?
I do not see.
So you might have gotten it, but you just don't remember.
I
I have no question further.
if something was done that was I have limited change. I would accept post
Regret. Any questions based upon the question that you can step in. Any other witnesses? Any exhibits? Okay, so you rest. Any rebuttal? Any evidence from the auditor's office? Argument?
Your Honor, as with the Winfield policy, it is all necessary steps to take to ensure the notice is sent to the interested party's record, given in a manner reasonably calculated to inform the owner. The first thing Whiting is trustee of Trust 1865, the pending loss of his interest in the real estate involved here, and there were two parcels here. The owner of record is in fact Center Bank, the First Bank of Whiting, trustee of Trust 1865. The evidence indicates that received all of the notices, the notices were properly sent, and that the tax deed in this matter should be issued. With respect to care of, and this is SSAY Corporation. First of all, SSAY Corporation is not a corporation. You couldn't even look further to actually find SSAY Corporation or any other address or anything associated with it to give any additional notice. The matters were sent to the address. The notices were sent to the address 4-5 and 4-6 notices by regular mail and not returned by the post office from that, presumably forwarded to this individual that just testified. I believe that notice is adequate. Whether, again, as I indicated earlier, whether the notice is actually received is not necessarily required under Gupta, as long as the intent to get it there and all the steps were taken in order to ensure that notice, the best notice possible was given. That's exactly what took place in this case. The owner of record was notified, and
It is a position of the respondent that there was failure to substantially supply tax dollars, particularly in light of the fact that the property record card indicates that it could have been directed to care of SSAY Corporation. Because it is argument and not testimony, I didn't interrupt her speaking, but I do want to address something that she said. He indicated that SSAY Corporation couldn't have found what they looked. That's directly in opposition to the testimony that was presented. Colette Lieutenant Stendhal testified if you were to look for SSAY, you would find in the Illinois Secretary of State. So I wanted to address that without.
Why would somebody look in other states at their on their Secretary of State websites to try and find a corporation?
Because due process requires, because as petitioner's attorneys, I would like to search all things, particularly in light of the fact that this address was in Illinois. That's where I would probably look for a corporation. So I think that if the question was posed to Attorney Grassi, he would say that he would look in other states, and in fact has sent me correspondence telling me and suggesting I look at the Illinois Secretary of State to find out who registered agent is for a particular country. Because the goal is to get everybody noticed.
Well, yeah, but it doesn't even say up on the registration.
It says care of SSAY.
It doesn't say on the registration. It just says COSSAY.
Right, which is why I would.
But it went to the same address. I mean, are you saying if there's a typo in the name, if it's John Smith and you spell it John Smythe, and it goes to the address and John Smith signs for it, that somehow it's confusing? And that doesn't substantially comply? And
According to page 9 of Inlay the Matter of 2007 tax sale, I would say that yes, it does. And in addition, you have testimony that SSAY Corporation had a forwarding address. Because there was no SSAY on the envelope as testified by Attorney Grassi, it would not have been forwarded under the forwarding notices. Had the address included SSAY Corporation, it would have been forwarded to the appropriate P.O. box, allowing the current beneficiary time to redeem the property.
where was that evidence? I didn't hear that.
Which evidence?
What you just referred to.
Well, it was kind of it was pieced together. Attorney Grassi testified as to the addresses on the notices. Sue testified that she had a forwarding notice put in place for both John Baber and SSAY.
There was no evidence that the post office would have forwarded something because it was minus somewhere. I didn't hear any evidence of that. I think that's what you just said. Is that
Because the corporation name wasn't on there at all. If the corporation name had been on there, then it would have been forwarded. You know, I can't send a piece of paper to Robert Van and then say, well, I meant it to go to John Craig, and if it was at the same address, well, they should have known it should have gone to John Craig. You know, it has to be the name on the forwarding slip. And what was testified to is SSAY was on a forwarding from that 2135 address, Western, to a P.O. box where the beneficiary did receive mail that was forwarded to SSAY at 2135 Westchester to her
okay?
P.O.
Well,
box.
I took that testimony to be that the forwarding address was First Bank of Whiting, Carolina. So that was also.
She said, what she testified to was SSAY. But I would direct the court to review the in-rate matter of 2007 tax sale.
That's this.
I think so. On page 9 it says,
So you mean Hewlett versus LaFavor?
That's the case.
yes, and then, but it also cites Reader where it says that the county auditor's address of record for the property was an office building in Illinois, care of C/O, Lawrence I. Serling. The auditor sent property bills to the proper address, but left Serling's name off the address so the bills were not received. This is exactly what you have in this case. It was left off. It's in the property transfer card. That's in the evidence report. But it was left off the notices, including.
Well, where's the evidence that it wasn't received? Because I think the evidence was that they were sent first class mail and they didn't come back, which would create a rebuttable presumption that they were delivered. And if I saw right, at some point in time in this group of exhibits, I saw that certified mails came back unclaimed.
Well, unclaimed, as this court has told me in other cases, isn't good service. So what do? You go to the next step and you go to publication. And publication under 5.
The statement was, the only reason I addressed that was the statement was it didn't get to the front.
Didn't
the
get to the
evidence would
proper
indicate
owner.
to me that it did get to the property.
Sorry.
I was just simply addressing the statement that, therefore, because it didn't have C-O-S-A-Y Corp, it didn't. I think that's what it said.
Right.
And my only response to that was the indication by the evidence was that Attorney Brown said he sent it there as address to the trust, and that it never came. And he sent it there by first class mail.
I guess I take issue with
let me
as
finish. And that it did not come back, which would create a rebuttable presumption that it did reach that address and did not come back. And then I just simply pointed out that the certified mailing, from what I could see, one of them says it's one of them said unclaimed. Is that the 4.5? Anyway, I just was curious as to why you were saying that the evidence showed that they didn't make it to the property address. I'm not sure that that's what the evidence was. Which simply means she doesn't know whether she did or she didn't. I mean, she was very forthcoming that, I mean, basically the evidence was she doesn't know. She may have, she may not. So that really gets me nowhere. What gets me somewhere is
The fact that SSAY was not included, yet there was a forwarding address for SSAY and that address that would have sent it to a PO box. That didn't happen. Because even though it was in the public record, and the case it requires that if it says C/O with the name, that it be included in the name address of the party. In addition, SSAY Corp is listed as care of in the transfer cards, which could indicate that it does have some interest in the property. And a review for the registered agent could have resolved that as well. Similarly,
it was Exhibit 9 I've looked at before. It says that it was, that indicates to me that they delivered it to, or at least put a note in one of the forms in a mailbox that said that it was attempted on, looks like March 31st, and then again on May 23rd, and then they sent it back saying return to center unclaimed.
And 135 question, not have the mailbox. Had the SSAY Corporation been not been named as required by case law?
I guess what I'm asking though is where is that evidence that they were unable to forward it to the PO box because of the absence of that?
Because she testified that she's only put the forwarding on John Davo and SSAY Corp.
Yeah, but this may not have been forwarded because it expired. I mean, forwardings only last for, I think, 6 months. They're not in perpetuity.
She testified she did in January of 13th. This is May. So even under that theory, it should have been forwarded if the SSAY Corp had been included in the name that was supposed to be pursuant to the transfer record in the county record. When it's contained in the auditor's, it's required to be in the name. And I can cite the court Bob White or where they say it again. Because it didn't contain the agent's name, it was contained in the county records. It did not come forward with the process required. And that's what you have here. No matter which way they try to spin it, that we serve this over here, that's not what the records show. The records of the county show care of SSAY Corp. The testimony before you is that had they looked for SSAY Corp in Illinois, they only would have found one SSAY. And in addition, unclaimed has never been something that I've known the court to hold as good service, which would require that 5134, I believe is the statute that talks about publication, be done as a secondary step pursuant to Johnson v. Flower. That requires that two publications in two different newspapers for general circulation be done. What's before you is only a publication in one filter or the lower.
Anything else? Reply.
Yes, first, down the subsection. Really. Notice there wasn't received at any address. I think you're missing the point here. We've got notice. We've got things signed by the bank and the trustee of this trust. They got the notice. They may not have actually received one that went to 1230, whatever the address is at Westchester. I mean, I don't know. We know we have one that's unclaimed. But the actual receipt, again, isn't required under the effort needs to be made to get the best notice possible. That's what was done in this case. And in fact, notice was received. Whether I got it in Westchester or whether I got it in Timbuktu, they got notice. That's what's required here. And you can try to find defects or tiny defects that aren't substantial at all in different notices, but if they got the notice, we've complied with the statute. They have, the purpose is to give them an opportunity to come in and redeem their property, to let them know it's gone for sale, and come in and redeem it. They've got notice galore. We've got notice at least 2 addresses on every notice, 3 on some. The evidence is sufficient. It is substantial compliance. There is actual receipt, Your Honor. They got it. And we believe the deeds should be
That's actually not correct. We're going to bring up new evidence, and I'll actually direct you to your own records, which you can look at to show the tax bills in 09 going to SSAY rate. 29, 210, 211. They actually show attention SSAY or 2009 to that. That's by electronic. Electronic ones only. Yes. The real paper ones did not have it switched over. I don't know why, but at some point in time, when you look at the tax bills, I think 10, they actually have attention SSAY.
All right, same schedule as the other case. Take it under advisement 30 days to file your proposed judgments along with your supporting factual findings, and I would prefer, again, the conclusions of law, so to speak, to be more in a memorandum. Yes. Either way. And the parties wait because of the timing of giving you the 30 days to brief it. I have to ask if you're going to waive 53.1 and 53.2. What do you want to? Well, and you waive on the previous one also, sure, right? The Winnering LLC. All right.
Thank you, Judge.
You're welcome. You're welcome. Indiana Operating Partnership versus Vivian McCardle. 45 Seal 1, 1109 MI 115 concerning key number 45-03-106-332-006.000-024. Attorney Wiley is here on behalf of Lake County Auditor's Office along with Representative Gina Scheit. Attorney Kovachkov appears on behalf of Indiana Operating Partnership. Do you have any representatives with you?
No, Your Honor, we've sent discovery to counsel. There's no objection to the exhibits we're going to
Okay, hold on.
submit.
I'm not done setting the record. Attorney Cohen is here on behalf of whom? Ryan Collins. Okay. And we're set for hearing on petitioner's verified petition for issuance of tax deed
Yes, Your
and the objection thereto by Mr. Collins. Okay. Are we ready to proceed?
We are, Your Honor.
Okay. Okay, well, let's see what their evidence is. Let's let them put on their evidence and we'll go from there. Attorney Kovachkov, you ready?
Yes. Again, for agreement, we're going to submit notices and envelopes that were used and sent. Exhibits 1 through, exhibits 1 through 8. And you got, Your Honor, after you see these, you'll see that notices were all sent as addressed in the auditor's
I'm
record.
not contesting the fact that they may have noticed the problem. I'm contesting to serve the owner. Yeah.
Okay,
Yeah,
we'll get there.
I'm
He
just
just
trying
has
to
to
make
put
it-
in his evidence first.
I'm just trying to create I'm creating a record on it. And then I'll let Client approach.
Yes. What are your exhibits marked as? 1 through 8. Any objection to petitioners 1 through 8? 1 through 8 submitted.
We have no other
Do you
evidence.
have any other?
We have no other evidence.
Attorney Cohen, do you have any evidence that you wish to submit? Mr. Collins? Turn and raise your right hand, please. Please be seated.
Please state your name for the court. And Mr. Collins, where do you reside? And that's the property that's the subject matter of this tax sale. And did you know Vivian Ricardo? And who's your friend? And Have you have knowledge of her death? When she died? And no further questions.
Attorney Kolachkoff?
How long have you lived at that property? Do you knowledge of anybody, any of Mr. Carl's relatives in the state? You have no ownership interest? Do you knowledge that anybody ever notified the county that Mr. Carl had died? Who paid the regular bills of the house? Who was supposed to pay the taxes?
Steve Rex? Attorney Wiley, do you have any questions? Okay, you may step down. Any other witnesses or evidence? Okay. Attorney Kolachkoff, any rebuttal?
No.
Attorney Wiley, any evidence or Attorney Kolachkoff? It's your original motion or petition, so argument, you get to go first.
Your Honor, all the notices in front of you were sent per statute. The one item of evidence missing is the follow-up letter that was sent to that address after the 4.6 notice. Because it came back unclaimed, it was clear that it got there because they showed up at the 4.6 hearing that they were notified. All the notices were sent. All of them were sent according to statute. There is no obligation on petitioner. The statute requires the petitioner to determine whether or not the individual owns the property is alive or dead. There is no obligation to notify the tenant. There is no obligation to open an estate on behalf of a deceased person. So we've met all our obligations. It is, in fact, an obligation on behalf of the heirs to open this estate if they wish to preserve their property rights, to either open the estate to transfer that interest to the heirs or transfer the same by a small estate affidavit, none of which is done. Consequently, you think that the issue is entitled to these?
What about the fact that as would appear in the auditor's record, the holder of a substantial property interest of public record was deceased. Your position is that the pre-sale notice and the 4.5, 4.6 don't have anything to do with either. It doesn't matter whether they're...
The argument, Your Honor, is without her death being of public record, I have no obligation to notify her here.
Attorney Cohen?
The obligation Yes, sir.
I agree with all of those. I just wonder for just conversation purposes is how would one go about doing that prior to a tax sale? How would they even know that they need to open an estate?
Doug and I have had this conversation. My opinion was that he should have gone in and opened an estate on the property, half of his lot, and served, notice served, the beneficiary, if there are any beneficiaries, and served the beneficiary with notice.
But how would that save him from an argument that the pre-sale notice was defective?
It won't. You can't do it. The one nice thing about Wilford is it said there's an exception in Wilford. And the exception is, the only exception to this, where this is the notice, is where a motion for relief from judgment of legend tax is void from the constitutionally inadequate notice. I'm saying the constitutionally inadequate notice is basically very simple. You can't serve a dividend. Well, I don't know how else to state it to you. I think in these situations, it is a very difficult issue, and I think probably the assessor's office, they are committee to come up with some kind of statutory remedy. At this point in time, the only remedy is open the state to the other state. And if you can do it as a creditor, you pay their taxes, and pick up their taxes, and open the state. And then it had no defense. Meantime, I'm going to have to renegotiate. Even if we were to agree, yes, thank you, now that we said it's clear sale to the property without having something open for the title early, and the tax man to go over the notice to the business.
Attorney Wiley,
Water has no section. Stop your instead. To advise the auditor what you think public records have. Very actually kind of a clear partial just when he taxes away, he doesn't mean he's going to pay taxes. Or by the way, that's how they can rent the property to somebody else take money from not just paying rent. It was specified. In addition, in the case, I think it's different where it says, basically what it says is, how you send certified download to the address of record with the auditor. That's the only thing they can go off. The auditor's address record. Those are supplied by the owner, or the owner's heir, or whoever. That's not done. That's not the fault of the buyer. Not the fault of the auditor. That's exactly what he did. He sent the notice. And in that situation, he said, we're going to have to prove an actual receipt. Which we can't.
has anybody looked, not to interrupt, has anybody looked to see if there's any cases in Indiana or other jurisdictions that address an issue of serving tax sale notice on a deceased person?
I've looked for Indiana.
I will state that I looked at the whole case.
Well, I've read it.
It says that the reason for giving notice is to inform the owner. Sure, if there's no problem with the notice having gone out. I can certainly inform the owner.
Well, I understand that what Attorney Wiley's pointing out is, unfortunately, the law in this area, there's not one hard and fast answer to any particular question because there's always competing legal obligations, so to speak, that the court has to take into consideration and weigh. And essentially what Attorney Wiley's pointing out is there's a whole body of case laws, I'm sure you're aware, that really kind of almost says, to trigger all of these constitutional protections that you would be entitled to, you actually have to take some affirmative steps to begin with, i.e., put your address down. You know, make sure the auditor knows your address, because otherwise people could skirt the system simply by not putting their address down or saying, I didn't get it. I've had cases of that come up. Well, you know, I had problems where the mail was getting delivered and it would get delivered to one place in my little condo unit and not my condo unit, and therefore I didn't get it, and therefore I should be absolved of any responsibilities, you know, under the statute. And you know, these things all kind of, you know, how do I resolve this side of the table's concern that, hey, you know, the people that were the rightful heirs didn't do anything to protect their interest in the property. So if notice went to the property, you would presume that the heirs would get it there, or if they...
I do have a response.
Okay.
And I think his argument is fair. Other, there's no equitable proverb, but if you sit on your, you know what, that's where you end up. The county could have filed a tax lien against the property and foreclosed on the lien. At which point, 10 years ago, they could have opened the estate and taken the property. It wasn't done. So they shouldn't be given a free pass for failing to follow up and protect their own interests. That's all I'm saying. I think it's a two-way street. And I agree with everything you're saying. I'm not arguing with you.
Okay, Attorney Wiley, I
think it's a really peculiar situation. I don't know if it's ever come up in here before. But it seems to me it's a very difficult issue to resolve.
I haven't had the issue come up. Attorney Wiley, I cut you off, so I'm going to let you finish what you were...
The auditor's obligation to make sure that people keep their address. That's exactly what happens. But in order to get equity, you have to come before like not paying taxes, knowing that your grandma died 15 years ago, you haven't paid any taxes on the property. Grandma. No, he said his friend's grandma.
Your Honor, the two hands work both ways.
In order to do equity, you must do equity. Right. So in order to get equity, you must do equity. So, yeah, I understand. Right?
Can I throw something out there?
Sure.
When Mr. Collins was talking about the fact that our person testified today, he cuts both ways.
Well, that hasn't been lost on me.
There's no stand for this person. If he's here on behalf of the family, that's one thing, but that's not what he's testifying. Now, secondly, I'd like to... Well, let's get to the meat of it, though. The creditor in this case, telling you have the creditor open state, the creditor in this case is Lake County, not my client. And the things that the court has to look at in the various cases that are being cited to are basically come down to the burden to be placed on the state versus the loss of property to the other side. So the burden that Mr. Cohen is talking about is having the county open in the state for everyone that they learn to be able to sell their property. I don't think that's a burden that any court would impose upon.
Well, that's part of the reason, you know, we had the discussion, the varying duties here that, you know, have to be weighed essentially when you're talking about the constitutional issues. And, a lot of the cases basically come down to the fact that the person in the position most easiest to solve the issue from the very get-go, or make it so it's not an issue, is the property. Is that person simply has to make sure that the auditor has the right things. And it all kind of starts from there. And then all these other things kind of come in, these competing interests. Because one thing I'm concerned with is you almost, if a relative passed and you were the sole heir, you're almost presenting a situation where that sole heir could just do exactly what Attorney Wiley was talking about and continue to enjoy the use of the property, live in it, perhaps run it out, all the while not paying taxes, and there would be little or nothing the county can do other than take these steps that you're stating. But even if they did, don't they have to open an estate prior to even the very first tax sale? I mean, or wouldn't your argument still apply? Would they have to sue on the taxes themselves and get a judgment? I don't know. I'm trying to figure out some scenario where.
Your Honor, in either case, they have to find out how do they do that. What effort does the county have to go through to find out who's died to be able to open it? You look at the county health department of your county in the United States.
Probably could.
We may get into that issue in May. Even if I don't know what May is, I was amazed. They even found disciplinary things on Google, which to me was almost uncanny as anything. The problem, Your Honor, I'm not sure what their title policy shows the full title on the car. But I would think that the title company would have had, if they had searched the death record, should have done, would have turned it up. But it is a catch-22, and I realize it. I think that the simple way to make sure you get through anything is go in and open a creditor's estate and then move their deed with the county, and the county can do anything they want with it. I mean, they serve the beneficiaries. Yeah, listen to what I'm going to say.
Yeah, but
if
that
the beneficiaries come in, their only option is to pay the taxes, and then they're not going to want to pay them.
I could see, if they get legal representation, I could see someone coming in and arguing that the pre-sale notice was a fact, even under that circumstance.
Or you could take,
Yes.
Since it's land, Your Honor, they can't take a position for $9 million. Taxes. It's not this. I think it's a different scenario. It is a crazy situation. And by the way, the only reason Mr. Collins came into court is because but his client.
That's why we changed our name. We made it a lot shorter. Because with Savanovich, if you screw that up, you can imagine what that comes out as.
I went to school. Serbia is part of the United States, to the heart. At any rate, Your Honor, he wasn't served. The purchasers came to him and wanted to make a deal. That's how he got to come to court. And then he had no authority to stop it. He had no deal. So that's how it came up, and that's how it worked. I
All right.
I guess the court has to find a way to resolve this.
Well, what I'm going to do is I'm going to take it under advisement and let you file your proposed judgments with findings of fact and your legal argument. I'd like for you to, both of you, present to me what you believe the legal resolution of this case would be. I want you to present that within 30 days. Give you an opportunity to put that together, 30 days. All parties weigh 53.1 and 53.2 since it's a 30-day time frame.
Petitioner Wayne.
What's the exact date?
Well, that'd be 8 plus 22, May 22nd. That's a Thursday. Is that sufficient time? Parties weigh 53.1 and 53.2. Attorney Cohen?
Yes.
Attorney Kavachkov? All right, very well. That will conclude this morning's call. Anything else? Here's the exhibits. Yeah.
Thank you.
You're welcome. I did not see it.